Okay, welcome everybody to the fourth and final installment of PMCA's Employment Law Fundamentals series. Thank you so much for being here today. I'm Lori Rawlings. I'm the Executive Director of PMCA, and I'm going to go over a couple of housekeeping things before we get started today. The first is, although we are having an attorney, Allison Kruger, present information here today, we're presenting general information for educational purposes to assist you in spotting issues within your own business. Allison is not providing legal advice today because all employment law situations are very fact intensive. So if you have an employment law situation within your company, you will need to consult your own attorney for legal advice. We are recording the session today. So feel free to turn off your cameras if you don't want to be recorded. If you would like to ask questions, feel free to use the chat feature. You can send me a question anonymously or in the regular chat, and I'll be monitoring the chat throughout the presentation. Also, feel free to raise your hand or just jump in with a question as Allison goes through the topics today. And with that, I'm going to introduce our distinguished speaker here today. Allison Kruger has more than 20 years of experience as a management side employment lawyer, representing small, medium, and large size businesses, as well as nonprofit entities in cases involving claims of discrimination, retaliation, wrongful termination, harassment, and breach of contract. She's got a very lengthy experience litigating all kinds of claims related to employment law and other areas of law. So I'm thrilled to have her here today. Thank you, Allison, so much for being here, and I'm going to hand it over to you.
Okay, thank you so much, Lori. Thanks to everyone who's joining us today. We have quite a few slides to get through, so I'm just going to jump right in. And as Lori said, if you have questions, feel free to post them in the chat, and we will also hopefully have a little bit of time at the end to answer any additional questions that you have. So our fourth session today is basically to cover miscellaneous topics, and there are many. So I'm just going to get started here. Hopefully, if I can get my screen to cooperate. Of course I can't. Okay, so there we go. All right, so our first topic is going to be paid sick time. And starting with Oregon, hopefully all of you are familiar with this. Oregon requires paid sick time for employers with 10 or more employees, 6 or more in Portland. And an employer must provide up to 40 hours of paid sick time per year. Employers with fewer than 10 employees, fewer than 6 in Portland, must provide up to 40 hours of unpaid protected sick time per year. So even if you're a very small employer, you still have to provide unpaid protected sick time. And I would urge you to take a look at this BOLI sick leave poster, which provides all the basic information about the sick leave law. Employers may not count the use of protected, paid, or unpaid sick time against employees under their attendance policy. So that's really a critical thing to be aware of. If you have employees using paid or unpaid protected sick leave under Oregon law, that cannot be counted against an employee under your attendance policy. Basic requirements, it applies to all employees, part-time, full-time, temps, seasonal employees. It applies to everybody, exempt, non-exempt. Accrual is immediate upon the start of work, 1 hour for every 30 hours worked, or 1.33 hours for every 40 hours. And an employee must be permitted to accrue up to 40 hours per year. Exempt employees are presumed to work 40 hours per week. And employers can choose to front load at least 40 hours at the beginning of the year. This is a way to kind of avoid some of the tracking and administrative burdens of the hourly accrual method, is to just front load 40 hours at the beginning of the year. Eligible employees must be allowed to use their paid sick leave or unpaid sick leave 90 days after their employment begins. And they can use it for many reasons, including their own illness, family member illness, injury, mental illness, doctor visits, public health closures. There are a few other items there too. So there's a broad range of uses that are permitted under the law. Employers must track accrued and used sick time and let employees know how much sick time they have earned at least quarterly. And employers are only required to allow employees to use 40 hours of sick time in a year and may limit the carryover from one year to the next up to 40 hours per year, and can cap the total accrual balance at 80 hours. So, this is a way to avoid having an employee accrue, huge number of sick leave hours that they never use up. Employers are not required to pay out unused sick time at termination. However, it is important to state that specifically in your policy, that you either do or don't pay it out. That's a sort of a business decision to make. Some employers prefer to pay it out because maybe employees won't use it all up and they'll come to work instead if you want them to. Others prefer to just require their employees to use it or lose it, but it needs to be stated in writing. An employer can require medical verification in only limited circumstances, and that is where the employee takes more than 3 consecutive work days of sick time. The need for sick time was foreseeable, and at least 3 work days, or the employee has not given notice. Employer must pay for the cost of the verification. Okay, moving on to Washington. Washington also requires paid sick time, but it's only for non-exempt employees, and it's 1 hour for every 40 hours worked. So different calculation from Oregon, and it's again regardless of full-time, part-time, temporary, or seasonal status. Employees' unused paid sick leave balances of 40 hours or less must carry over from year to year, and employees are eligible to use that after 90 days of employment. So again, this is non-exempt employees only in Washington. Again, like Oregon, in Washington, an employer cannot discriminate or retaliate against an employee for using protected sick time or filing a complaint about the use of protected sick time. And again, it just cannot be counted against an employee under the employer's attendance policy. Uses under Washington law: care for the employee themselves or for a family member. And in terms of paying sick leave, it must be paid in the same pay period that it was used, except if the employer requires verification for 3+ days of sick leave. An employer must have a written policy if they are going to require verification. And employers must notify employees of their sick leave rights by their first day of employment. Okay, California. For those of you who have employees in California, basically in California, employers must provide 1 hour of paid sick time for every 30 hours worked, or have another approved accrual method. Employers may cap the accrual at 48 hours and cap the use of paid sick time at 3 days or 24 hours, whichever is greater, within a 12-month period. So California, like everything in California, is just a lot more complicated. Some local governments have their own paid sick time requirements, including San Diego, Los Angeles, Santa Monica. So if you're doing business in California, make sure you've got a California lawyer who's reviewing your sick time policies for compliance. Also, basic requirements: it can be used for diagnosis, care, treatment of existing health conditions, preventative care, including annual exams, flu shots for an employee or family member, and also if an employee is a victim of domestic violence, sexual assault, or stalking. Qualifying employees are those who work for the same employer on or after January 1, 2015 for at least 30 days a year in California, and they satisfy 90-day employment period before taking leave. Okay, that's paid sick leave in a nutshell. Whistleblower protection. So this is one slide on an enormous issue that every employer needs to be aware of, really, in every state that they have employees in. Employees who report actions that they believe violate local, state, or federal law are protected by whistleblower statutes in Oregon, Washington, and California, and it is illegal to discharge, demote, suspend, discriminate, or retaliate in any way against a worker for making a good faith report. Oregon employees are also protected for opposing unlawful employment practices. That's also true in Washington and California under federal law. And a report doesn't have to be substantiated for the whistleblower to be protected. All that's required is a good faith belief. So these can, span all kinds of issues, reporting health and safety violations, environmental violations or suspected violations, wage and hour violations. I mean, it's a very, very broad category, but it's just something to be aware of if you're thinking about terminating an employee. Have they complained about anything recently? What have they complained about? And do we need to talk to an employment lawyer about whether we might have a whistleblower claim if we terminate this person? So as I said, one slide on an enormous topic, but just something to keep your eyes out for. Okay, Oregon paid family and medical leave. I'm actually going to kind of skip through these slides because the Oregon legislature, this was supposed to go into effect January 1, 2022, but it got moved back a year because of the pandemic. So I'm going to suggest to Lori that sometime next year, we do just a session specifically on Oregon paid family and medical leave, because it's something that nobody right now probably has the bandwidth to digest. And we also are waiting on the administrative rules to come out from the employment department, which will give us a lot more detail about how this program is going to work. But basically, starting in 2023, all employees in Oregon will qualify for paid family, medical, and safe time leave as long as they earn $1,000 in the base year or alternate base year. It's basically a program like unemployment, and it's going to provide a state paid benefit to workers. So like I said, I'm going to skip through this now, and we can come back to this next year and talk about it in detail. The implementation date, though, just for future reference, January 1, 2023 will be when employers are required to begin making contributions, and written notice will have to be given to employees and so forth. And then benefit eligibility as of right now is September 1, 2023. I suppose it's possible that will change again, depending on what happens, in the next several months with the pandemic. And then eventually employees will have a right to sue for violations of the statute. But this is something to just kind of have on your remote radar for, next year. Okay, let's move on to the Oregon Workplace Fairness Act. This is Oregon's response to the Me Too movement, and it requires employers to adopt written policies to prevent and reduce discrimination and harassment in the workplace. The policy must describe the process for reporting discrimination and harassment, identify primary and alternate persons responsible for receiving reports of such conduct, specify the statute of limitations applicable to an employee's claims, state that the employer may not require or coerce an employee to enter into a non-disclosure or non-disparagement agreement, but there are some exceptions to that, and advise employers and employees to document conduct, including sexual harassment. So this statute was a major change to Oregon law. There isn't a single employer in the state of Oregon that would have had a policy that complied with this statute at the time that it was passed. It actually went into effect in 2019. And I think the policy became required last year, although maybe it was 2019 because I feel like the years have now run together. But in any event, it's in effect now. So if you have not updated your harassment and discrimination policy, you need to do it. It's actually a violation of the statute not to have an updated policy, which, I don't know that there have been too many claims brought about that, but it's certainly possible for there to be one. And for sure, if you get sued for discrimination or harassment, if your policy isn't up to date, you will also be sued for violating the law for not having an up-to-date policy. So it'll be just an additional claim that you have to deal with. So I highly recommend updating your policies. Good news, BOLI has a model policy on their website, and you can go to this link and it will take you to a page that describes the basic requirements of the statute. And it has just a nice standard template. And I've recommended it to almost all my clients, instead of reinventing the wheel, to just adopt the BOLI model policy, make sure that you provide a copy to each employee at the time they're hired. Make sure that it's available within the workplace. Make sure that your employees receive and sign for receiving a copy, or if you update your handbook, that you're getting a new acknowledgement from all of your employees, and that you keep that in their personnel records so you have proof that you did notify employees of the new policy. Additionally, if an employee makes a report about conduct that is prohibited by the policy, they are supposed to be given a copy of the policy at the time. So there's really, it's a really big change for Oregon employers, and something to be aware of and on top of, and to make sure that your managers are aware of it and your HR folks are aware of it. The other pieces of this statute that are important to know about is that it bars the use of non-disclosure and non-disparagement agreements that prohibit an employee from discussing discrimination, including sexual assault and off-premises incidents. So this is a significant impact for employers who use severance agreements or use some sort of non-disclosure agreements in their employment process, that you have to be careful that you are not asking employees to not disparage the company, because that can cover this type of conduct. And so, that type of clause in either an employment agreement or a separation agreement or severance agreement should just not be included. It does permit the use of non-disclosure or non-disparagement agreements when it's requested by the employee, or when it involves a management employee that the employer determines has engaged in discrimination or harassment. So there's sort of narrow exceptions there. But if you're going to, go this route, make sure you're getting some advice from an employment lawyer so you don't make a mistake and violate the law. And also, employees who are asked to that fit into the narrow exceptions have to be given 7 days to revoke an executed agreement. So it's really an added hassle, and you have to think about whether it makes sense to even bother with it, and what the risks are there. Other changes that are significant to be aware of: the Oregon Workplace Fairness Act increased the statute of limitations from 1 to 5 years for basically all of the sort of simple discrimination type cases: age, sex, race, religion, sexual orientation. All of those types of claims are now, and I've probably missed a few categories, but those are all now 5-year statute of limitations. Used to be 1 year, now it's 5 under Oregon law. Federal law is 300 days, but federal law, for all intents and purposes, in Oregon is almost moot because Oregon law is so broad and covers more than federal law. And so an employee doesn't have to bring a claim under federal law. They can just sue under state law. And now they've got 5 years. And that also applies to BOLI complaints. So you can have an employee terminated 3.5 years ago, and something happens and they decide they're going to go to BOLI now. And everybody that worked for the company then is no longer with the company. And maybe you don't even have the documentation about the employee anymore. And that's going to be a thing. So something to consider is your personnel record and document retention policies, and whether you want to expand the length of time that you preserve records about your employees in case you do have a lawsuit or BOLI complaint that comes in, 4 years and 11 months after the employee was let go. Okay, moving on to Oregon Ban the Box. This has been in effect now for about 5 years, I believe. Oregon employers cannot require job applicants to disclose on an employment application that they have a criminal conviction, or to disclose that prior to an initial interview. If no interview is conducted, then they cannot be asked to disclose it prior to a conditional offer of employment. Can't imagine there are too many people getting offered jobs without an interview, but in this job market, I suppose that's a possibility. So this is something to be aware of. And note, you got to take the box that asks about criminal convictions off your application forms. This applies to all employers unless they're exempt, and that's a pretty limited number of employers, those that are required to consider an applicant's criminal history: law enforcement agencies, criminal justice system, and non-employee volunteers. This does not prohibit employers from notifying applicants that they will later be required to disclose convictions or that a criminal background check will be performed as part of the hiring process. So you can still do the criminal background check. You just can't ask about it before you can't ask about it on an application or before an interview. The law does specifically state that employers may consider convictions when making hiring decisions. At this point, the enforcement is through the Bureau of Labor and Industries only, and there is no right to sue in court. That may change. Portland banned the box. This is a little bit different. 6 or more employees, the majority of, so this applies to employers with 6 or more employees, majority of work in Portland. The law is just stricter for Portland-based employers. Again, cannot ask before making a conditional offer of employment. After making a conditional offer, there's an individualized assessment that may be done and can help you determine whether you can rely on the information. Certain criminal record information is off limits, and notification is required if the offer is rescinded. Some of the same exceptions as under Oregon law, and there's additional exceptions that are, applicable only to really very specific employers. Okay, moving on to the Oregon Paycheck Fairness Act. This is also a fairly new law. I think it's been on the books since 2016, 2017 timeframe. It is unlawful for an employer to discipline, discriminate, or retaliate against an employee who inquires about wage information, discloses or discusses wages, or makes a complaint based on such disclosures. There's some limited exceptions for, HR people who are involved in wage matters, but this is a major trap for the unwary. And I'll give you an example. I'm dealing with a case right now where an employee questioned the use of sick time by her supervisor. And she is claiming that that is protected activity under this statute, and is claiming that that's why she was terminated. That's not why she was terminated, but in any event, it covers things that you wouldn't think it covers. So you got to be careful about employees who are talking about wages in any way and terminating their employment, in the same time frame where they are talking about, inquiring, or complaining about wages. Okay, Oregon social media privacy. When this law passed, which was the same time as the workplace or the Paycheck Fairness Act, I thought this is a solution looking for a problem, but perhaps there are employers out there who do this. Under Oregon law, an employer may not demand access to an employee's social media account. Employers may not require employees to maintain or establish an account, and employers cannot refuse to hire an employee due to the lack of a social media account, or demand that employees allow the employer to advertise on their personal accounts. I mean, I would say, keep your business separate from your employees' social media. That's just, in my mind, is a good idea. And social media account is read really broadly, so it definitely includes things like LinkedIn and Facebook and Twitter and everything else. So you just need to be careful about what kind of expectations you have around employees and their social media. Oregon Equal Pay Act. So I'm sure all of you have heard about this. This made a lot of news when it was passed. Under Oregon law, employers may not pay employees differently based on any protected classification. So this can be very complicated to figure out. Wage levels for comparable work must be equivalent. However, disparities in pay are allowed where the employer has bona fide reasons for the disparity. And the bona fide reasons include things like seniority, merit, production-related metrics, workplace locations, travel needs, education, training, or other experience, or a combination of those factors. It also allows differences in compensation in a collective, if it's based on a collective bargaining agreement and bona fide factors. Also allows pay differentials for employees working modified duty as a result of an injury sustained at work that is covered by workers' compensation. An important point to note here is that it's not just job description specific, that you have to pay everybody that has the same job description at the same rate, or be able to differentiate based on one of the bona fide factors. It's work of a comparable character. So if you have two employees who do different kinds of work, but the work is very similar in terms of substantially similar knowledge, skill, effort, responsibility, and working conditions, regardless of job title, those jobs should be paid the same. And an example that I often give is something like, your finance director and your IT director. Are those positions comparable? They might be. Operations director and your HR director, those positions might be comparable. So you really have to look closely at the positions to determine whether they involve work of a comparable character or not. You can't just say, well, this is, this type of job, this particular job, and then we have this other job over here, because the jobs themselves, if you look at them carefully, may actually involve quote unquote work of a comparable character. There is a safe harbor for employers to avoid certain types of damages if they can demonstrate that they completed an equal pay analysis of pay practices within 3 years before the date an employee files a lawsuit under this statute, and they've made substantial progress to eliminate a wage gap for employees. This is really complex, and I would say if you want to go down this road, you definitely want the guidance of an employment lawyer. You may want to hire, an expert to do this type of review. I've had a couple of clients who have done this, and it's kind of an interesting process, but it's not something that I think is for the faint of heart or to necessarily be done internally unless you're a very small business. So there's a safe harbor there. Also, importantly, this kind of ties in with the ban the box stuff in terms of what's on your applications. The Oregon Equal Pay Act prohibits employers from seeking salary history information of an applicant or an employee. So you should take that off your application forms if it's on there. It's unlawful for employers to have applications that ask applicants to disclose what they were paid at prior employment. And BOLI has the authority to enforce this and issue civil fines. And the thinking here is that, some people, in particular, women and certain minority groups, have historically had lower wages because they go to a new job, they're asked, what are you being paid at your current job? And their pay at their new job is kind of tied to what they were making at their old job. And so the pay inequity just is perpetuated in time from employer to employer. So, and this type of law is being passed in other jurisdictions. I actually believe California may also have a similar statute. And beginning January 1, 2024, employers will have the right to sue potential employers who've inquired about their salary history. And I'm sure there are going to be cases about this because it's a very easy kind of claim to bring. There's Exhibit 1 is the application with the box that said, what were you paid at your last 3 positions? Okay, so under the Oregon Equal Pay Act, if someone sues for a violation and they're successful, they can recover their unpaid wages. They can recover non-economic damages, so their emotional distress over the discrimination they suffered in pay. They can get punitive damages and attorney's fees. So you can have an actual claim that may not be worth a whole lot because maybe the pay differential was only $1 an hour, but the person has $100,000 of emotional distress. They ask for $200,000 of punitive damages, and by the time you get to trial, it's $200,000 in attorney's fees for their attorney, plus what you're going to pay your attorney. So you can have a relatively small claim that can end up, costing the company $500,000. And I know that sounds scary and unrealistic, but it's absolutely the way these cases go. And employers are also required to post pay equity notices at each work site. Fortunately, BOLI has provided a template that can be posted, so make sure that you are posting that notice. Okay, moving on to Oregon pregnancy-related laws. These are some changes that came into effect a couple of years ago involving pregnancy. And it is an unlawful employment practice for an employer to take any of the following actions against an employee or applicant based on limitations related to pregnancy, childbirth, or a related medical condition. Denying employment opportunities when based on an applicant or employee's need for reasonable accommodation and the employer's desire not to want to provide it. So basically, pregnant employees are entitled to accommodation under the same terms as a disabled employee. Failing or refusing to make a reasonable accommodation unless it imposes an undue hardship, and all of those scenarios have to be evaluated on a case-by-case basis. Taking any adverse employment action or discriminating with respect to hiring, tenure, or any other term or condition of employment because the applicant or employee has inquired about, requested, or used a reasonable accommodation for pregnancy or a pregnancy-related medical condition. Requiring an applicant or employee to accept an accommodation that is unnecessary for the person to perform the essential duties of the job, or to accept a reasonable accommodation if the person does not have a known limitation. You know, this is a call I've gotten many times over the years where a client will have a pregnant employee and they're worried about the employee performing certain job duties, but the employee hasn't asked for any accommodation and the employer wants to kind of force one on the employee. And so this is trying to address that paternalistic behavior that, frankly, pregnant women have had to deal with for decades on the job. And so if you've got a pregnant employee and there's a concern about the work they're performing, talk to your employment lawyer before you do anything about that. Also requiring an employee to take OFLA if the employer can otherwise make a reasonable accommodation. That should say employer. If a pregnant employee or one with a pregnancy-related medical condition can work with some sort of reasonable accommodation, you can't require them to take OFLA. Okay, again, employers must post signs providing notice of the employee's rights under this law and must also provide a written copy of the notice to a new employee at the time of hiring. Existing employees within 180 days of the effective date of the statute, so that date's already passed, and an employee who informs the employer of the employee's pregnancy within 10 days after the employer receives that information. So kind of important changes to the law in Oregon on pregnancy. Washington, some additional Washington specific laws. Washington now has a sexual harassment model policy, so I would urge you to take a look at that if you have employees in Washington. Washington also has an Equal Pay Act, and there are a number of requirements there for employees, similar to Oregon. California also has an Equal Pay Act, and it's somewhat different from Oregon's, but similar in some respects. So I would, definitely recommend looking at that one. California also has some other unique laws. We could, spend all day just on California's unique laws, but this is one that requires a private employer with 25 or more employees to provide reasonable accommodations for an employee to participate in a drug or alcohol rehabilitation program, and workers who are denied a reasonable accommodation may file a complaint with the labor commissioner in California. So this is somewhat similar to what's required under OFLA and FMLA, but slightly different. So if you're doing business in California, that's something to be aware of. California also has a ban the box law that's somewhat different from Oregon. So take a look at that. We also have California law also prohibits employers from asking applicants to disclose information concerning arrest, detention, processing, diversion, supervision, so things that are not convictions, and does not allow employers to use that information as a factor in just determining hiring if it relates to all of those things, or when the person was a juvenile. So something else to be aware of in California. California law also prohibits an employer from using a prospective employee's salary history to determine whether to make an offer of employment and to determine what salary to make the offer of employment, and is also prohibited from seeking personally or through an agent the applicant's salary history. So this is another, issue under California law, that you should not be asking for salary history. And there are many other restrictions under California law that are too numerous to address here. So I'm not licensed in California. And when I have clients that have California specific needs, I typically refer them to a colleague in California. So I recommend, if you're doing business in California, that you have a California employment lawyer. Okay. So our last official slide, and I've really sped through this, but that'll give us some time for questions and for our quiz. But I wanted to talk about this because I know Lori's still getting questions about it, and I still get questions about it. And that has to do with COVID-19 vaccination status, which is, number one on the minds of a lot of employers these days. A lot of clients of mine, and I'm sure you've all heard, news reports of this, that a lot of employers and government entities are now requiring vaccination. And so there still is a lot of questions about, can I ask my employees about their vaccination status, or is that violating the law in some way? And the answer is yes, you can ask. An employer may legally inquire about vaccination status and require proof of vaccination from their employees. This is not a medical inquiry under the ADA, and it does not implicate HIPAA. HIPAA has almost nothing whatsoever to do with private employment. The only time that it does is if the employer is a healthcare plan or a healthcare provider itself. And none of the people participating in this call would fall into that category. And even in those instances, HIPAA applies very narrowly. HIPAA really is a law that applies to what your healthcare providers and your healthcare plan do with your medical records, and not what employers do with medical information about their employees. HIPAA just does not apply whatsoever. The ADA does apply to some extent, but the Equal Employment Opportunity Commission has made it clear that employers may inquire about vaccination status. They may ask for a copy of the vaccination card or other medical record that discloses proof of vaccination. Employers may not require the employee to provide any other medical information beyond vaccination status as part of proof. So if an employee, has some document that says they were vaccinated and they also have 5 medical conditions, you don't want that document. You only want the document that shows their vaccination, that they completed their vaccination series, the dates and what vaccine they received, and where they received the vaccine, the CDC card that we've all received, or an electronic medical record that shows just that information. Also, if an employee says, I've not been vaccinated and I have a reason for that, don't ask them why, unless they're asking for an accommodation. If they're asking for an accommodation, so if you were to decide you wanted to have a vaccine mandate, you need to allow for at least the consideration of exceptions for medical and religion. Medical reasons and religious objections. And in those instances, you are allowed to ask follow-up questions, but you have to do it carefully and appropriately. And you probably need some guidance in deciding whether you're going to allow the exception or not if you decide to mandate the vaccine. So I would urge you to get legal help with that, not try to manage it on your own. In those cases, you can ask additional questions. But in terms of just asking your employees, are you vaccinated? And they say, yes, I am. And you say, we need a copy of your card. That is not covered by HIPAA, and it does not violate the ADA. I would recommend, though, that you keep that information in a confidential file, that it's not that it's kept separate from other employment records, and that it's protected as confidential information. And that's just a good practice, and what the EEOC recommends as well. Any questions at this point?
Thank you so much, Allison. Yeah, feel free, anyone in the audience, if you have questions, if you want to jump in, great. If you would rather put it in the chat, feel free to put it in the chat. I'll be monitoring that. So I'm going to give people a second or two to jump in. And if not, we can move on to the quiz, which is very good enrichment in terms of going over what we've learned today. I don't see anyone with hands up or anything in the chat, so I'm going to go ahead and launch the quiz. This is not graded, it's anonymous, so feel free to answer the questions just to test your knowledge. I'll give everybody a few minutes to do that, and then I'll close it out and Allison will go over the answers. We had 100% participation on the quiz. Great job, everybody. I'm going to go ahead and close it out and share the results, and then I'll read the questions and Allison will go over the answers. So question 1, true or false? Under the Oregon Equal Pay Act, it is legal for employers to ask prospective employees what they were paid at a prior job. Allison, what's the right answer?
The answer to that is false. It is not legal to ask that question.
Excellent. Excellent. Great job, everybody. Okay, question 2, true or false? Employers with fewer than 10 employees in Oregon, fewer than 6 in Portland, must provide up to 40 hours of unpaid protected sick leave time per year. Is that true or false, Allison?
That is true. So congratulations, everybody got that one right.
Excellent work, everyone. Okay, and question 3, for what purposes may employees in Oregon take protected sick time? An employee's own illness, an employee's family member's illness, employees' doctor appointments, or all of the above? What's the answer, Allison?
All of the above.
Excellent work, and a good suggestion having the all of the above option this time, Allison. We had some issues last couple of quizzes with the multiple choice. So, well, great job, everybody. You were all paying attention and you did a great job. At this point, I'm going to give people another opportunity to ask questions. There's no such thing as a stupid question. And I know we covered a lot of material today, so feel free to jump in or throw something in the chat. You know, Allison, while we're giving people a little extra time, I just wondered if you could elaborate on why there's so much misinformation about HIPAA. Why people think they are banned by HIPAA from asking about vaccination status. And there's a question in the chat. Yes, I will make the slides available after the meeting. So
yeah, I wish I knew the answer to that. I mean, I would like to say it's social media, but I was telling Lori before we started today that probably 15 years ago, I had a client ask me to help with a project, and their primary worry was that they were going to somehow violate HIPAA. It had to do with an online application program. And we got onto the call and I launched into a big explanation about how HIPAA didn't apply at all to what they wanted to do. And, that it just wasn't anything they needed to be concerned about. And I explained why and kind of walked through it, who does HIPAA apply to and who doesn't it apply to. And after about 15 minutes of me talking, they said, okay, well, thank you so much for all of that. We really appreciate it. Now, we just really want to be careful. So we want you to just look at what we're doing and tell us how we can comply with HIPAA. And I just kind of threw up my hands and said, okay, what you're doing complies with HIPAA because HIPAA doesn't apply to this. So I think it's just I think there's been a lot of misinformation about HIPAA going back, way before the pandemic. I mean, I've gotten phone calls for years from clients about people in the workplace talking about someone who's ill and a concern that maybe there's a violation of HIPAA going on, or just things that just have nothing whatsoever to do with HIPAA. There are restrictions on employers sharing medical information, but it's the ADA that applies. And it's really, employers should limit the disclosure of medical information only to those who have a need to know. So if you have an employee who's out because they're having surgery and you need to tell the supervisor that, look, this employee's out on medical leave and they're going to be out for 4 weeks, that's okay. That information can be shared. The specifics about what kind of surgery and all that doesn't need to be shared and probably shouldn't be. But it's okay to share, this person is on medical leave. And for if people want to talk about their own health issues in the workplace, that's not a violation of HIPAA or the ADA. An individual can talk about their health all day long if they want to. And I tell clients, just don't try to put a stop to that. You have to really be careful about what you do with people that are, maybe giving out too much information at work. But it definitely isn't a violation of HIPAA or the ADA if employees choose to do that.
Thank you so much. That's helpful. Okay. Well, I don't see any other questions in the chat. So
it looked like there's 2 up there now. Is that?
That was the question about whether the slides would be available after the meeting.
Okay.
And just to thank you that they will be made available. Okay. So I think then, unless people jump in, we can go ahead and finish up a little bit early today.
Hi, this is Katie at TCM. I have a quick question.
Yeah, please.
Sorry, I couldn't find the mute.
Yeah, no problem.
So, I completely understand the HIPAA or non-HIPAA piece. Like, that's been a challenging conversation for a lot of us. One of the things that have come up is around the stickers that are now being used at a lot of the job sites, right, to identify individuals. And as far as who's been vaccinated or unvaccinated. And, just being cautious in that arena and making sure that, that there's choices involved in some of that. Is there any either best practices or things for consideration that you would recommend, making sure that we're dotting our I's and crossing our T's as we go through that? Because I'm hopeful in that space that would allow people to, negotiate their health preferences and how they interact. But, this can also lead to discrimination then, and some of the other pieces that play into it. And so I know we're walking through this minefield right now of, what do we do next? And I guess, I don't know if you have any input that I would love to hear on it.
Yeah, that's such a good question, Katie. I mean, I have recommended to clients that certainly not requiring employees to identify whether they're vaccinated or not. Mm-hmm. That is, posting a list of vaccination status, that potentially does violate the ADA. Mm-hmm. So, it's one thing for the employer to ask for the information and to keep that information in its confidential records. And it's okay to mandate that people be vaccinated or apply for an exemption and then determine whether they qualify under the ADA or Title VII for a religious accommodation. But sort of requiring disclosure of vaccination status, I think is problematic. And, you know, I guess if people choose to want to wear a sticker that says I've been vaccinated, I wouldn't necessarily stop them from doing that, you know, if it's a personal choice. But I guess I'd want to know sort of what's being done and how is it being done. And so I'd probably need a lot more details to give you a better answer. I would suggest if you guys have regular counsel, employment counsel, that you chat with them.
Yeah, and we have, I mean, this is, you know, we're working also with clients and GCs and what,
Yeah.
right, they're choosing to do at their levels. And then, so it gets complicated pretty quickly. So when you say, you know, the HIPAA piece, it's such it's shining a light in the wrong direction. But as soon as you start digging into the real direction, it's like, whoo, it gets complicated real quick. So
yeah, I mean, there are a lot of, there are potentially a lot of issues there. It is okay to ask. It is okay to require proof, you know, for the employer to do that. But then there are a lot of limits on what you can share and who you share it with and how it
right.
gets shared. You know, I've seen a number of times employers or businesses that have had a little thing on their website. You know, everyone that works here is vaccinated, and I as a customer, I feel like that's great. You know, I'm really glad to know that, and it makes me want to patronize the business, to be honest, because I don't have to be concerned about that. But even that, you know, I think there's probably a question there of whether that's really in the clear or not.
Yeah, well, some of our recent discussions have been around personal feelings versus, you know, looking at it from a business perspective and a business risk. So, okay. Well,
Yeah, personal feelings are huge in all of this, for sure.
It is. Yeah.
So, yeah, I would say, you know, if you've got employment counsel, I would lean on that person, and maybe it's something to, you know, get your stakeholders together to have a conversation about.
Oh, don't worry. We've had lots of conversations. Yeah, no, I was just interested to hear your perspective on it. So thank you.
Yeah, absolutely.
Thanks, Katie. Great question. Anybody else have any other questions? Okay, well, Allison, thank you again for everything. This has been a great presentation. The whole series has been very educational. So I just want to thank you and your colleague, Lauren Russell, for all of your hard work and insight in putting together this series.
Absolutely. It's been fun. I know Lauren's enjoyed working on the slides, and hopefully, you know, next year we can have some new content. And again, you know, the Oregon paid family medical leave program, and who knows what else.
Yeah, it's a date. We are definitely going to need to do an update on the new Oregon leave law. So
Great.
I appreciate it. And thanks to everybody who took the time to join us today. All right, I'm going to wrap it up. Thanks, everybody. Have a great day.
Thank you, Lori.
Bye-bye.
Bye, everyone.
Thanks.
Thank you. Take care.